SJC-12635, Chelsea Housing Authority v. Michael E. McLaughlin and another.
Mr. Rosia Ricapuro? We're all yours, at least for 15 minutes.
Thank you very much, Mr. Chief Justice, and may it please the Court. Ronaldo Rosario Recupero for Appellant Chelsea Housing Authority. With me, Richard C. Pedoni. On the brief, Patrick McDonald, and we recognize the contributions of law student Darius Brown to our case team. This is a case of first impression in Massachusetts of a private CPA asserting the in pari delicto doctrine against their public agency client in order to achieve complete immunity for their own negligent conduct. Plaintiff CHA is a cash-strapped agency which serves some of the most vulnerable families in Massachusetts, and it was victimized by an executive director who engaged in a 10-year scheme to steal $1.2 million in public money for his own benefit.
As long as you started on that issue, what about the damages, the $2.7 million? Is there any reasonable chance that the Chelsea Housing Authority is going to have to repay that?
That is the case, Your Honor. As we set forth in our reply brief, it is customary that HUD seeks repayment for funds that were misused. And in the course of the scheme that allowed Mr. McLaughlin to steal the $1.2 million, he misused an additional $2.2 million, which is being recaptured by HUD. And that is why we have brought this action specifically against Mr. McLaughlin as a joint tortfeasor, as well as against these certified public accountants, these defendants who we believe were negligent in the performance of their duties. And yet, despite the fact that over the course of the 10-year scheme, these auditors and accountants were engaged to perform fee accounting and auditing services for the Chelsea Housing Authority, but never made one report of misconduct during that entire time, and are now asserting that the doctrine of in pari delicto, an equitable doctrine, should prevent them from paying even $1 in contribution to the damages for the millions of taxpayer funds that their negligent conduct resulted in harm to the Chelsea Housing Authority for.
Are you saying that there should be a special carve-out for public entities, or?
We believe that this court's hearing decision in Merrimack noted that with respect to each individual application of in pari delicto, the court has to look at the individual equities. And we're saying in the equities in this case, especially because the amount of negligent conduct that occurred and the special equities that are available to public agencies, especially a cash-strapped public agency like the Chelsea Housing Authority, which is required by statute to spend taxpayer dollars to hire a certified public accountant to perform certain audits. The equities are strongly in our favor and are against the certified public agency.
You're not suggesting that this is the first the failure to give notification was the only failure to give notification, are you? I mean, everyone knew, didn't they?
With respect, well, the question is, we brought action against multiple tortfeasors in this case.
The fact that they didn't give it doesn't mean that other people didn't.
Yeah, we're saying that they had a role in contributing
No, but other
to the
people
damages.
knew. Other people who were in the know, there were people who, like the board and so forth, they knew that these things were going on. Did they not?
No, we brought action against the board for their own negligence in failing to bring have fiduciary maintain their fiduciary duties back to the housing authority. The board members, we argued, had fiduciary duties to the housing authority, which they breached because they should have known that their misconduct was occurring.
Told them. Other people told them.
These auditors and accountants, these two defendants, said nothing over the course of that 10-year period.
Other people did, didn't they?
No, Your Honor. With respect to these board members, there was no evidence.
Should have known rather than a known.
It was a should have known, and they were statutorily immune, as the trial court found that they were statutorily immune from their obligations. So we brought action against all the potential tortfeasors in this action, and all we're simply saying is that the certified public accountant defendants should pay their portion of share and not have what the trial court did here is allow the in pari delicto doctrine to supplant what the legislature adopted was a particular scheme that allowed CPAs who met certain criteria to limit their damages to what this court last year referred to as a comparative negligence scheme. That comparative negligence scheme would say that if an auditor and accountant can establish that they were not willful and knowing with respect to the conduct at issue, and that they themselves were defrauded by the conduct of any other party, they can limit their damages to no more than their, quote, percentage of fault.
But we're talking about senior management here.
Absolutely, Your Honor. And the statute specifically recognizes that that in the CPA context, where we have a CPA who is invited to look at the book and records of a CPA client, there will always be some level of imputation. They're only looking at those books and records because they have some relationship to the CPA. If the CPA believes that there was some conduct that prevented them from doing their job in a non-negligent manner, for example, if these auditors and accountants can, at the damages stage, prove up that they were defrauded by Mr. McLaughlin, the board members, the finance directors, that's where they have the opportunity
Let me
to
ask
say
you
what
about
they would
that.
be able to do that.
Because it seems to be somewhat shifting your application of the statute 87A and 3/4. So initially, it was raised, and walk me through this, initially it was raised as a defense by the accountants, correct?
Yes, that's right.
And then in your papers, your summary judgment papers, it says that the statute's not applicable.
Yes, and it's
Okay,
not
but
applicable.
now
at the
you're
summer-
saying it's applicable, so I'm trying to get how that can be. And I get your reading of Merrimack as well, that after damages are assessed, then it's comparative negligence. But how does it supplant, if at all, imperi delicto, and how is it consistent or inconsistent with your arguments down below?
Sure. With respect to the arguments below, we argued it below, so we have it satisfies preservation with respect to Atwater. But with respect to
Well, I
sat.
thought, I've got your summary judgment papers,
Yes.
and you say it's not applicable.
We
So
say
how's
that
it
these
preserved?
defendants have not found it applicable at the summary judgment stage because we understood at that point that there would be an apportionment of damages once all of the tortfeasors are found. It is essentially a liability cap statute. And that is why we believe that they have not proven up, one, that they were not knowingly and willfully.
No, I get
participating
it
in
now
the
that you were saying it wasn't applicable at the summary judgment stage, not that the doctrine, not that the statute's not applicable.
Exactly, and that's why this court had the insight in Merrimack to recognize that the statute has had the effect, exactly in this case, of supplanting the statute, because what these auditors and accountants have done and what the trial court's decision does, it says you never even reach the statute because imperi delicto stands in front of it. It forecloses the further up.
So you want us to apply the public policy part of Merrimack to your case, accept the housing authority, and then if there's liability found, the statute kicks in for comparative negligence?
If they can establish that they qualify it for it, because they've proved, they've pled it as an affirmative defense, so it's their burden to establish that they would qualify for the
But
statute.
that's down the road.
Exactly, and that's what we're asking for, to find summary judgment as to liability, because we move for summary judgment solely on liability in this case, and we believe they have liability. The court assumed that they were negligent, recognized that they had some level of culpability, and yet still gave them complete and total immunity so that they pay nothing, even though a statutory scheme has been set up that would.
That's an awful big lot to chew on.
That's what we thought. That's why we brought the appeal, because it flies in the face of what the statute what the statute envisioned, which was joint tortfeasors.
But aren't there material facts that would preclude summary judgment in your favor?
As to liability, we don't think so. We believe we have a strong case of liability, specifically because the role, and I would point your honors to the brief of the Department of Housing and Community Development. They describe in great detail the special responsibility that auditors have in the public housing context. They are the regulations require that we hire an independent auditor and spend taxpayer money to do so, because the housing authorities have limited resources.
Moderato wasn't an auditor.
Excuse me?
One of them wasn't an auditor.
One
right?
wasn't an auditor, one was a fee accountant, but the statute speaks to CPAs, and their professional responsibility flows to CPAs regardless of what particular work they're doing. And in both that particular work, they are not permitted to, they are obligated to report misconduct, and they are obligated not to subordinate their professional judgment, which occurred in both of these cases.
What about when their clients hide? Mel?
They have the opportunity at the damages stage to establish that they were defrauded. If they have not yet done so here, and if they can do so at the damages stage, that's why the statute actually quite carefully determines that there will be joint tortfeasors. Last year in Merrimack, this court described the exact situation that we have here, where the main tortfeasor, we believe Mr. McLaughlin, the one who literally took the money and put it in his pocket and masterminded the scheme, may be most responsible, potentially even, as the court mentioned in Merrimack, 70% responsible. There remains some level of contribution that should be required, especially because we have a public agency and public dollars, which, as I was saying before, there's a particular role for CPAs who are required to do some of this work for public agencies because of their independence. Those reports, for example, that Mr. Scaffidi's firm was obligated to perform are sent not simply to the board of the Housing Authority, but to the funders of HUD. We are not the same as a corporate entity that can take the determinations of an audit report and put them in a drawer and take the risk that there would be no action against us. The Housing Authority's members are immune from liability, and the reports go to HUD specifically because they have limited ability for the Housing Authority board members, many of whom are obligated to, there's no requirement that they have particular financial expertise.
Can I slow you down for 1 second, just because you're going very quickly? So in peri delicto, has it been applied differently in a quasi-public context? I mean, it's a common law doctrine. I assume it's been around for hundreds of years. Do we have cases in which we don't treat government the same as we do the private sector?
We haven't found an application of in peri delicto in the public agency context within our research. We don't believe it has been.
I mean,
And frankly, Your Honor, it's because we believe, and we believe, frankly, this court's reading in Merrimack means that you don't actually have to reach that, because this court's...
well, I don't know if that's true. It looks
Well,
like
the court's
I mean, it cuts against you. If we don't create a public exception, we have senior managers here. We didn't have senior managers there. So don't you need this public exception to get out of the in peri delicto doctrine?
Not necessarily, Your Honor. In both pieces of the Merrimack case, with respect to the case in which the statute forecloses the field of in peri delicto, we believe, and which we endorse that reading, and we believe that reading is correct, where the statute has covered the field, especially because exactly what happened here. Here we had a carefully considered statute where they could limit their liabilities. The trial court said in peri delicto steps in front of that. It would make no sense, especially in this very case, that in peri delicto gets to step in front of a statute that the legislature crafted to carefully weigh those liabilities. So in that case, and
we
that
don't
make no
need-
decision between senior and non-senior managers.
Okay, I'm just trying to understand how the different pieces fit together. So in peri delicto, there's the public sector exception, but we don't need to go there because you say the statute immediately kicks in and eclipses and we just go right to the statute?
That's correct.
But that's not what we said in Merrimack.
The court's ruling in Merrimack was it appeared to replace in peri delicto in the certified public accountant realm, and that's what we believe.
That was,
Well, that's a little strong. I mean, I know it was dicta, but that's a little strong.
well, I mean, since I wrote it.
The quotes, the legislature appears to have replaced.
In Merrimack, it was never raised by any party. It was raised only in the amicus brief. It was not briefed by anybody. And moreover, virtually all of the conduct at issue occurred before February 23rd, 2003, which was the date that the new statute took effect. So,
But these defendants have put that statute at issue because they pled it as an affirmative defense. They recognize that they believe that they should be able to get that protection.
but let me make sure I understand. Is there any conduct here that is before February 23rd of 2003 that's at issue?
Very little, Your Honor. There's some, but there's very little.
So is it your view that all of this conduct is governed by the statute?
Yes, virtually all, Your Honor.
Okay, you say virtually all. You're saying there would still be a common law piece to it if
There may
the
be
statute supersedes?
There may be a year or two of the conduct of Mr. Murato that may have fallen within that time period, but the vast bulk of the conduct at issue here occurred after February 2003 enactment of the statute. For example, in May of 2003, Mr. Murato knew that Mr. McLaughlin was taking incorrect salary amounts, and yet he failed to make any report whatsoever, as was his obligation. If he can establish that there was a reason that he should get the damages cap, that he was not knowingly and willfully participating in the conduct, and that he was defrauded by someone, he should get the damages cap. Otherwise, we believe that he remains joint and severally liable because, as the ICPA brief at pages 49 to 50 importantly states, when the legislature adopted that statute, they were writing on the assumption that joint and several liability existed as to CPAs who could be sued joint and severally with the main malefactors in this situation. And CHA has done exactly what the statute called for. It brought action against both the main malefactor, Michael McLaughlin, and the certified public accountants, seeking that they can make some contribution to the negligence here. The Housing Authority...
But I don't understand that, because if if imperi delicto does not apply, then we're governed by the common law, correct?
That's correct, and what the legislature understood the common law to be at that time was the joint and several liability scheme, and they stepped in and said, we recognize what the common law is, and we are, as this court referenced in Merrimack, it was understanding that in the certified public accountant area, some of that doesn't fit exactly. For example, there will always be some level of imputation because there will always be some level of the books and records that are being examined are the books and records that belong to the agency. If imputation meant that you would never be able to have some level of recovery from the certified public accountants, the result would be the result would be an incentivization of negligent conduct by auditors, accountants who are working for public agencies in this Commonwealth.
Okay, so I guess before we go further, is there any dispute that both Mr. Murado and Mr. Scafidi fit within the statutory definition of an individual or firm licensed to practice public accountancy?
No, they both asserted that that the statute applied to them.
They were. So, well, they claim the statute does not apply. They claim that the common law still applies. Okay, so if the statute does apply, you're saying it applies to them, but you're saying there may still be a common law overlay? What if, with regard to the board, you're not alleging fraud against the board?
We alleged negligence against the board, but they were found statutorily immune.
Okay, but they would arguably, that does not necessarily mean that the accountant could not be contending that they are, if there was a comparative negligence claim, if we're in the common law and we're in a world of comparative negligence, does their immunity mean that they could not be viewed as more negligent than the accountants and therefore would render under the common law, apart from imperi delicto, that the accountants would not have any obligation to pay?
That's exactly what we're asking this court to remand to have the trial court determine, because the trial court never apportioned damages across the joint tortfeasors in this matter. We simply want the auditor's accountants to be counted among the joint tortfeasors and not simply removed on liability by operation of imperi delicto.
And
So it should go back to the
what would be the
trial court.
consequence of if you persuade us that there should be a public policy exception for public entities, what then is the law that would govern? Comparative negligence?
With respect to as this court argued, asked the trial court to do, examine the equities in each case. That's our view. We believe
Okay, so let's assume they do it, then what happens?
if they examine the equities in this case, they should determine what percentage of liability should accrue to the auditors and accountants.
And what if the determination is that in this case, the board is more than 50% responsible?
That would be imposing a comparative negligence scheme, and that's not what the legislature did.
I understand, but the legislature is the legislation. The common law is the common law. And the legislation speaks about fraud.
Yes,
Acted fraudulently, but you haven't alleged fraud against the board.
they have the opportunity to allege fraud against the board. They could have cross-claimed or brought any other action for fraud against any other person. If there's anyone else who prevented them from performing negligently, non-negligently, they had the opportunity to do that at the damages stage, and that's what the statute calls for. And we think that this court was correct when it made that observation.
I'm confused. Can you do an example of the sorting? Say each of the accountants is 15% liable, and the board is 40% liable, and management is. Could do some math for me and show how the different things interact.
That's exactly what we think the trial court should be asked to
No,
do.
but I'd like you to take my hypothetical.
So I'll take the hypothetical exactly, and
So each of the accounting firms is 15% liable.
sure.
And the board is 40% liable, and McLaughlin is responsible for the rest of the mess. Do
And if
it for me.
And if that's the case, they
And
would.
do it under both, how it would work out, because there's comparative negligence, then there's the statute. Explain how it all works together.
Well, if they can qualify for the statute says that they cannot have any more than their percentage of fault as the trial court would determine. So given that, they would pay 15% each. Otherwise, they are joint and severally liable, and they exist in the joint and several liability scheme in which the parties
But what do you think the
satisfy
answer is? Are they jointly and severally, or does the statute trump joint and several liability?
The statute carves out from joint and several, as the legislative history at page 49 of the ICPA brief says, they were writing on joint and several, and they gave the statute to allow certain CPAs who can make certain claims that they would be protected from joint and several. And if they can establish that, they have their limitation on damages, otherwise they remain joint and several. And here, the only co-defendant is Mr. McLaughlin. Mr. McLaughlin, it would be among Mr. McLaughlin, Mr. Scafidi, and Mr. Morato. And the damages, we believe, should be apportioned by the trial court in order to determine what percentage, if any, they should be required to pay. But in any case, we believe it should not be zero. We believe in this case, there was negligence on the part of someone working with taxpayer dollars to perform work for a public agency in a specific scheme that they understood. They performed their act negligently, and for them to pay zero is in violation of both the equities and what the statute anticipated, Your Honors. I see my time has expired. Thank you.
Mr. Martinetti?
Mr. Chief Justice, and may it please the court, William Besh, and I represent Martin Scafidi, one of the two accountant defendants, and he was the auditor. Specifically, he performed annual HUD audits of the Chelsea Housing Authority's federal programs. My colleague, Ms. Reamer, represents John Morato, the so-called fee accountant, and we've split our time. She's graciously allowed me to go first. I have some points, but I'm sensitive to the court's questions about, and I agree that particularly on the facts of this case, how all of these defenses work together is a mindful. So let me see if I can give you my view in simple terms. I think all of the defenses, in particular, in pari delicto, the statutory apportionment defense, I call 87A and 3/4, I call it the apportionment statute, and comparative negligence, are all defenses we've asserted, and there's certainly overlap between the people and the conduct that those defenses involve, but there's no necessary conflict between the defenses, and in particular, no necessary conflict between the statutory apportionment defense and in pari delicto, which would lead you to say, oh, when the legislature passed the statute, they must have meant to get rid of in pari delicto.
So 87 3/4 is not supplanted by the statute because it doesn't say that it's supplanted, and they know how to do it if they want to supplant. They've done it in other contexts with contributory negligence.
Right. Not only does it not say it, but there's no logical inconsistency between the statute and in pari delicto. There is overlap, but there are cases where one applies and the other doesn't.
Okay, well, help me with that, because it applies only to fraud committed by the plaintiff
Or another person.
party. Okay, but it expressly mentions the plaintiff.
It does.
But under in pari delicto, if there's fraud by the plaintiff, in pari delicto kicks in and there's no liability for the defendant.
Yes, in pari delicto applies to fraud or other wrongdoing by the plaintiff that's sufficiently bad as a matter of equity that they shouldn't be allowed to come to court and sue for negligence. So the focus of the in pari delicto defense is on who is the plaintiff and what have they done, and are they in effect trying to sue somebody for failing to stop them from doing something they should have known was wrongful. So you're certainly right, because the statute does include the plaintiff and includes fraud specifically, although not other forms of misconduct. So, for example, in this case, the misconduct of Mr. McLaughlin and the other senior executives includes fraud, certainly. They defrauded the state by submitting the false budget forms, but it includes other wrongdoing as well. They they concocted this scheme where they got advanced information on what apartments were going to be randomly inspected, so they could fix up those apartments and get a higher score and get more money from HUD.
So what? I'm confused, though. Your job is to detect fraud, right? That's what, I mean, I have a little trouble trying to figure out the interaction between the auditor statute and in pari delicto, because, I mean, you're hired, your purpose is to prevent this kind of bad behavior, right?
That's not right.
Well, it's an important part of what an auditor does, isn't it?
That's not fair in this case, Your Honor.
Well, but I'm just trying to understand how in pari delicto works with that statute, given that the statute is directed at accountants and indirectly at auditors, and if any time there's fraud and you can't recover against the accountant and auditors, it seems to make the job of the accountant and auditors kind of superfluous. Tell me why that isn't the case.
Well,
I mean, your very job is to detect this kind of misbehavior, and if you're off the hook when that misbehavior occurs, it seems to be no purpose to no purpose to in pari delicto. I'm lost at how that all works
well,
together. Go ahead.
it's a fair question, and I think what it may get at, and one of the points that I would urge to the court today is this may not be a good case for asking that question.
Seems like a great case, because this is what it's about. That's why we've got a lot of shenanigans in these places historically.
Right, but none of them were within the scope of what this auditor, as opposed to the state auditor's office, was tasked to do.
You've conceded for purposes of summary judgment that there's negligence. You argue that you will prove that there was not if the case goes to trial.
No.
But
We have not- we have
for
not-
purposes of summary judgment, did you not say we're not contesting?
Absolutely not. Quite to the contrary. We argued below and we argue here. Of course, for the purposes of the
Arguing in pari delicto.
you have to assume, you have to look at how bad the plaintiff's conduct is.
But with regard to Justice Kafker's question,
Right.
we're not adjudicating here. I know that the other side says they should prevail on summary judgment. Put that aside, okay? Assume for the sake of this discussion and for Justice Kafker's question that there was negligence by the auditor, and then address the issue. If there's negligence by the auditor, why should there be no legal responsibility under in pari delicto and the statute? And then when you do that, you can then answer what the legislature was contemplating when they imagined that the plaintiff had committed fraud and still imagined the possibility of the auditor having to pay some money. So answer his question first.
I will address that question, although one of the questions the court must decide, depending on how it resolves the in pari delicto defense, is our argument at summary judgment and our argument here that there was no sufficient evidence of our negligence. So that was absolutely.
Again, assume that there are issues of fact.
I understand the question.
Which would prevent summary judgment as to that issue. So answer the question.
Yes. So if there was negligence and there's on the part of Mr. Scafidi, that was limited to. First of all, it was only negligence, and it was limited to the audit of the major federal programs of the Housing Authority. Nothing to do with the defrauding of the state with the false budget forms. Those were not documents that Mr. Scafidi was ever had an opportunity or reason to see. He never had an opportunity or reason to know about that scheme. So to say that he was hired to ferret out fraud is an oversimplification that's really not fair to what his retention was.
The CFP money, though, would have been, right? How the CFP money was being used.
That's right. And so for purposes of applying the in pari delicto defense, the Chief Justice is quite correct. You assume that Mr. Scafidi was negligent with respect to how they were applying the CFP money and should have ferreted that situation out. And you lay that against the fact that part of that scheme that was not part of Mr. Scaffidi's scope included the fraudulent inspection scheme and the fraudulent reporting to the state. And so what the Superior Court judge did is when you lay that intentional and fraudulent conduct against the, at best, negligent and limited in scope to one part of the overall scheme of Mr. Scaffidi, in pari delicto applies. In other cases, it may not. In other cases, where the retention of the auditor is to ferret out the very fraud that is at issue in the case, and it may not be appropriate to apply the defense, and the apportionment statute may kick in, and the auditor has to pay whatever his share of the overall damage is. But there's no reason to throw out wholesale the in pari delicto defense anytime you have the word auditor appear in the case, because it depends on what the auditor is being asked to audit. And that's what's key here.
Okay, so now turn to my question, which is, what was the legislature contemplating when they said that a plaintiff may commit fraud and still, an accountant may still be liable for its share of responsibility for the loss?
So the legislature was contemplating a situation where the fraud of the plaintiff is not so bad, so abhorrent, that they are barred at the outset of the case from even being a plaintiff, where the wrongdoing...
And how would that be possible under our in pari delicto doctrine, which you can infer the legislature was aware of?
Well, it's
fraud always trumps negligence.
But it's this, Your Honor, it's the same, the courts have always had to make the same analysis in the presence of the comparative negligence statute.
That's comparing negligence, not comparing fraud to negligence.
That's not quite correct, Your Honor, because in a comparative, to get back to the question of the defenses here, in a comparative negligence setting, you're comparing all of the plaintiff's conduct, not just, you're not isolating their negligent conduct from their intentional conduct. So it was always available to a plaintiff to say, well, don't apply in pari delicto to me. I'll take the comparative negligence statute. When we get to the jury, they'll assess some negligence against me. Don't kick me out from the outset because of in pari delicto. Let me go to the jury and they'll assess some fault against me. So it's the same overlap that exists with the apportionment statute as exists with the comparative negligence regime, which is both statutory and common law.
Okay, thank you.
you.
We'll hear from Ms. Reamer.
Have to lower that a little bit. Good morning, Your Honors. My name is Nancy Reamer. With me is my associate, Eric Martinetti, and we represent the fee accountant in this case, John Murado. The fee accountant role is different than that of the auditor. The fee accountant is a role that's created by statute, but in English, basically what he does is nothing more than a compilation engagement. He is not tasked with looking under the data. He's not asked to confirm that if he sees a receipt, let's say for $100, that it was really a $100 expenditure. That's not what the fee accountant does. So he's not held to the same standard here as someone who does an audit, which there's much more in scope. But what I'd like to do...
I'm a little confused, though. He just got up and said, I'm only responsible for this little thing over here. And you're getting up and saying, I'm only responsible for this thing over here. The problem is we've got this massive shenanigans going on, and neither the accountant nor the auditor is responsible for that? Who is?
Well, you know, I'd like to start actually by answering your question that you asked prior with regard to, you made a comment that an auditor is supposed to detect fraud. That's actually not true.
Well, an auditor, I mean, an independent entity has been hired and put in place by statute to make sure the books are accurate, aren't they? I mean,
No. Well, let me-
Having spent a lot of time doing those things in the past, we spent a lot of money on them for no reason then.
Let me
ahead.
correct the misconception. And this is case law and auditing standards. You need to remember that auditors are guided by standards set by the PCAOB, the Securities and Exchange Commission, the AICPA, the American Institute of Certified Public Accountants. There are FASBs, there are auditing standards, SASs, and SARs that all govern what and how an accountant acts. All that is set forth in the amicus brief filed by the
get it.
AICPA.
I get
But what an auditor's duty is, and this is crystal clear, and it's also set forth in the engagement letters that is signed by the client and the auditor. The auditor's duty is to express an opinion on whether the financial statements conform to generally accepted accounting principles based upon audits conducted in conformance with generally accepted accounting standards. So an auditor's job is not to ferret out fraud unless that's the scope of the auditor's engagement. And if that were the case, the Housing Authority could have hired an auditor to do a fraud audit.
So if they see that the listed salary is 100-something thousand and the real salary is 400,000, as long as it conforms to, as long as the pennies line up, it's okay?
No.
All right.
Because the rest of that sentence, what also happens in these engagement letters and what auditors say, if they find something that is a material error, mistake, or fraud, that's material to the financial statements, they have an affirmative obligation to raise it to the client. In this case, first you'd raise it to Mr. McLaughlin. Obviously, you wouldn't get anywhere with that, so then you would raise it to the board, or in this case, you would raise it to the state auditor. Now, it so happens, which Ronaldo has missed, is Mr. Murata did raise the issue with regard to Mr. McLaughlin's salary to the board. The board already knew it because they approved it. But the issue was raised. It just, they knew it and they still went ahead and they affirmed it. And that would be part of the defense in the underlying case if the summary judgment were overturned and remanded. But those are issues of fact.
Okay.
And for the purposes of summary judgment.
If the only issue was whether the judge erred in his evaluation of the facts concerning negligence, we wouldn't have taken the case.
Correct.
So the issue below was not the issue of whether or not you were negligent. The issue below was whether you have to go to trial and not be able to avoid trial under the doctrine of imperi delicto. So let's put,
Well,
if
I would like to
if
address
you
your
lose
question.
here and go to trial, maybe you'll prevail on the issue of negligence. But the issue is, why should you prevail on the issue of imperi delicto when we have a statute which specifically says if the jury were to find you negligent, they would, that the fact that Mr. McLaughlin engaged in fraud does not necessarily mean that you don't have to pay a fair share.
okay, now, that was the second point I wanted to address, which the question you've been asking. The statute and imperi delicto stand side by side. They do not conflict with one another. Imperi delicto only applies in an issue, in a case where the plaintiff is involved in either fraudulent conduct or some type of bad or wrongful conduct. There is a case.
But the statute expressly recognizes that the fraud may have been committed by the plaintiff.
Or any other party,
Right,
and it
but
also
the plaintiff.
Let's put it in a different situation. The statute would apply. Now, let's say there's a fraud committed at a company, and a bank relies on the financial statements to issue a loan, funding for a company. And the company executives commit a fraud, so it falls within Merrimack. But the plaintiff is the bank. The bank's not a wrongful party here. The bank didn't do anything wrong. All they did was rely on the financial statements upon which the auditor issued an opinion that at the time the financial statements were issued, they fairly represented the status of the corporation in accordance with GAAP on that day the statement's issued. And the bank relies on that. Turns out there's a fraud. They go and they sue the accounting firm. One of the defenses, now, imperi delicto is not a defense here because the bank was not the wrongdoer. It's not the wrongful party. But the senior executive at the company is. That's a situation where the statute would apply. There has to be a proven fraud, not just an allegation of a fraud, and it has to be a fraud. There's a case in the Commonwealth which dates back the
Okay,
Choquette case,
But the
which,
language of the statute says in which action a claim or defense of fraud is raised against the plaintiff or another party. So.
or other
I
party.
understand, but I know you want to focus on the other party. I want to focus on the inclusion of the plaintiff. So,
Plaintiff could be a defendant in that case. In the case brought by the bank sues the company, it sues the auditor, and it sues, let's say there's an SEC lawyer involved, or whoever else is involved. In fact, I've litigated that case. Instead of a bank, it was investors that filed suit. In that case, the statute would apply to apportion liability. In peri delicto does not apply. When you look at what an accountant does, an accountant's only on site at his client's office maybe 2 weeks a quarter if they're doing quarterlies. If they're only doing one audit statement, they're there for 2 weeks a year. They are 100% dependent and reliant on the information provided to them by the client.
Can I ask you a question, though? I mean, this is me. Can I ask you a question? I'm so confused. Now, if you have an accountant who you said detected fraud or detected the issue of excessive salary and disclosed it to the board, did you say that?
I did.
Okay. Was that reflected in the opinion then that the accountant gave?
Well, my client was a fee accountant, so he doesn't issue an opinion.
Issue an
He
opinion?
doesn't issue an opinion. Now, the accountant would not necessarily put that in the opinion, but it would certainly be in addition to the audit opinion that the accountant issues, there's also a separate letter that goes to the board of directors, and it has any findings that would be in that audit, that would be in that opinion, in that letter that goes to the board of directors. It would be in there. And in a separate control letter that is issued. Now, this case is a little bit different because there was a HUD audit, and that's the other thing to remember here. HUD audited the Housing Authority. HUD itself found some discrepancies within the books and records, and HUD didn't do anything about it, and in fact, continued to fund the Housing Authority year after year.
Well, along those lines, with the apportionment point, the Chelsea Housing Authority said there's three parties for apportionment. The auditor, the accountant, and Mr. McLaughlin. I imagine that you would say that's not correct.
Correct. We would add in the board members, we would add in HUD, and we would also add in the State Department, which also was involved and did an audit as well. They don't have to be, and this is where the statute would come in.
State auditor, you mean?
State auditors, yes. They do not have to be named parties in the litigation to have a jury or a
That's my
fact
question.
finder apportion percentage of fault.
Because Mr.
to that
McLaughlin, for instance, along those lines, it wasn't a secret. His salary wasn't a secret. He gave an explanation that a number of entities accepted.
Right, and in fact, if you look at the statute, this is a perfect example if the Chelsea Housing Authority were not the plaintiff. If there was a third party that were the plaintiff, the statute would apply, and it would be a perfect example because Mr. McLaughlin, according to my understanding, is judgment-proof. So what this statute is saying, and Governor Cellucci said this when in the State House News Report, which is contained, it's not fair that an accountant would be considered, in this case, the deep pocket. It would be the only one holding the bag where the lion's share of the responsibility here would go to Mr. McLaughlin. He walks away because he's judgment-proof. The board walks away because they had immunity. The state auditor would still be involved in our position is that the state auditor and HUD would still be involved, but let's say the only two pockets here are my clients and Mr. Scafidi, the auditor. Why should they be bearing 100% of the responsibility where they may only be 10 or 15% responsible?
But why
So
shouldn't they-
recognizing.
But aren't you arguing that they're not even responsible for the 10 or the 15%? You're saying you're completely off the hook. That's what I don't get.
Well, I'm saying 10 or 15, I'm just,
Well, but
raising
why don't you walk through the statute for a second? Just when an individual, you meet the first part of this, right? Right?
yes.
In which an action or an action, claim, or defense of fraud is raised against the plaintiff. Just so we've got a fraud against the plaintiff. And that plaintiff is found in the pending action, and the fraud was related to the performance of the duties of the individual firm. Isn't that true, too? We're meeting that clause, too, right?
Right, in the sense that the information upon which the accountants relied was fraudulent, because that's what the client gave them, was fraudulent
Right,
information.
the client gives you fraudulent information, and you don't detect it, I know you want to fight about that, and I get that.
Outside.
But I don't understand why you're not responsible for your percentage under this statute. I don't get why imperi delicto trumps that.
Because the wrongdoer here is the corporation,
But this
the entity.
But the statute expressly, as the chief pointed out earlier, it expressly says that we're going to hold accountants to their percentage of liability. Am I missing something in the statute? I just don't get it.
Because the statute was not meant to replace the centuries of common law of in peri delicto. This statute
What
was
is
meant
this?
when the plaintiff was not the client.
Why? That's crazy. It's the first part of the statute. The plaintiff is, why wouldn't it be?
Not necessarily, and there are other factors involved. And as we've said, if the legislator wanted to overrule in peri delicto, they could have. And they would have in fact stated it in the statute, as it did when it overdid
Done by
joint and several
implication.
liability.
You know it can also be done by implication.
However, that's not usually the case, and you do have Governor Cellucci's comments, who is the one who advocated and lobbied for the statute. I have researched this myself in multiple occasions in cases with the few of you who have actually been involved in a lower court.
I'm very interested in that part of it. Governor Salute, you're talking about the signing message from the governor, is that it?
That is the only legislative history
And
that
does
exists.
it
with
mention
regard to
anything
this.
about the common law at all?
He talked about joint and several liability.
But he
And he
doesn't-
said that that was not equitable, that was not fair to the accountant, given the accountant's role, and the fact
But he
that the
doesn't
accountant
talk
is
about it.
100% dependent on the information provided to him or her by the client.
But there's nothing about in peri delicto in the statute.
Because it wasn't meant to overrule in peri delicto.
Well, I
Had
mean-
it had that purpose, it would have said it.
Is there anything in the legislative history that anyone was talking about in peri delicto? Because the legislatures, it's not their bread and butter in peri delicto, right?
Well, the legislature was fully aware of the concept of in peri delicto.
Is
They
it-
knew
is
it existed, they knew it had been applied, and think about it.
is
There
it-
have been
oh,
numerous cases.
I've spent a lot of time dealing with the legislature. So is there anything in any of the bills, the prior bills, or any legislative back and forth about in peri delicto? Because I find you can't assume they're really up to speed on the latest common law.
Well, in this statute, when this statute was enacted, there is no mention whatsoever in peri delicto.
So
What I
it's-
can say,
It's absent from any of the prior bills or any signing statement or anything else.
my understanding is this was the first time this bill was presented to the legislature. It's not like it's a bill that had been presented and failed. This was the first time it was presented. But since this statute was passed, there have been numerous cases before the courts, including the appeals court, where in peri delicto has been found to govern. AGM,
Did anybody ever raise the existence of the statute? No
yes,
cases?
yes. In fact, I can tell you for a fact
Which case?
that
I
in
don't remember you
Canby
citing.
Maloney,
Sorry?
AGM Marine versus Canby Maloney, which is mentioned in the AICPA's amicus brief, that was raised. And the lower court, Judge Houston granted summary judgment to the accountant, Canby Maloney. That case was appealed, and the appeals court affirmed the judgment based on in peri delicto.
Do we have the cite to that case somewhere?
I can give it to you in 1 second, as it is in the AICPA's brief. I can also tell you
As long as
that,
it's in one of the briefs, we'll find it.
yeah, it is in the AIC, and I was counsel of record in that case, so I can tell you for a fact it was raised.
Okay, so.
By me.
So why should we not interpret what happened with the legislature is the auditors were concerned about joint and several liability? They don't have joint and several liability. But the price of all that is that you may have to bear your fair share of it, even when the plaintiff is engaged in fraud.
Because this court would be overturning decades of common law where, and it's the whole concept in the law that one who commits fraud or perjury or a bad act should not be rewarded for that act by being let off the hook and having another party, in this case the auditor or the accountant, assume any of the responsibility, no matter what that percentage share is.
Okay, but joint and several liability is decades old, too.
And there was a reason for that. There was a reason why, in the concept of an auditor, that was changed. And that had to do with the fact that the auditor is 100% dependent and reliant upon the information provided to him or her by the client. So when you have a situation where the client who commits a fraud is giving false information to the auditor upon which the auditor is relying. And even when the auditor asks the right questions, uncovers the right things, but the fraud is so sophisticated that they figured out how to cover it up that an auditor would not find it unless they did a fraud audit.
They're really sophisticated in this case, come on.
Well, that's why this isn't a great case for the certain Perry Delecto.
That's a little bit of a stretch.
No, but there are cases which have sophisticated frauds. Cammy Maloney was one of those. It was a very sophisticated tax scheme.
You mentioned a fraud audit. Can you explain what goes into that does not go into a regular audit, just
So,
briefly?
yes, a regular audit, the auditor is only looking at transactions that are material to the financial statements. There is a calculation which is performed, and the materiality comes up. They're not going to look at a single invoice or receipt or voucher or whatever that's less than that material number. So say that number is $600, okay? Any receipt less than $600, they're never going to see in a regular audit.
How about $300,000?
If it's less than 300,
Well, we're dealing with $300,000. What's the total budget of the Chelsea Housing Authority?
I would have to ask them. I don't know what that is.
Be a rough guess.
I honestly don't know. I don't want to make a misrepresentation to the court. But all I can tell you, the difference is in a fraud audit, they would look at every single receipt, every single piece of paper of whether that number was material or not. And it would be a lot more expensive than a regular audit. And that's the other part here. If you want to discourage accountants from doing audits, that's what will happen. If Imperi Delecto is taken away and you're relying on the statute, the cost of audits
I am
will skyrocket.
confident that accountants are going to want to keep doing audits because you got to get paid.
Well, but they may not want the risk. You know, the risk may be too great for what the fees would be in a case where there's any kind of skepticism or question as to whether or not the client can be relied upon and trusted. And if you have a company that, say, changes auditors every couple of years, you're going to have an awful tough time getting another auditor to step in and do that audit.
Could you help me? What was the point of hiring these auditors and accountants then? I mean, it seems to me like they're pretty useless.
Well, it was not to detect fraud.
What was it
The purpose
for?
was the audit was to ensure, with regard to the fee accountant, it was to ensure that the books and records were kept in proper format and when submitted to HUD and to the state office for the
Format.
funds.
That was
Format.
that was all that was
They're
required.
statutory, they had to hire them.
It's statutory, right? They're required to hire them. And
For
the
that
HUD audit-
purpose, for that purpose.
For that purpose. That's what the fee accountant does. It's a compilation. It's just like you hire a bookkeeper to put the income statement together with the balance sheet and the income statement. That's what a fee accountant does. He puts the numbers in the right order in the right location.
What was the point of hiring the auditor then?
The auditor was to ensure that the financial statements complied with GAAP in all material respects. And it was actually a yellow book audit, which is a little bit different because that's a government audit based on HUD standards. But the bottom line is it was still to ensure that the financial statements, and what they do is issue an opinion, that they conform with the principles of GAAP, and it's done in accordance with the principles of GAS, which is generally accepted auditing standards, which is different than GAAP, which is generally accepted accounting principles.
So is the general point then that at that point, once that letter is written, if there's an opinion letter, that is to advise the board things are going okay? When the letter goes to the board, things are going okay based on this audit, or you've got some issues here based on this audit? Why don't you look in these directions? No?
Yes and no.
Okay.
The opinion, yes, the financial books and records were performed in accordance with GAAP in all material respects. If there were an issue that raised in the audit, that would be in the separate letter, which goes along with the audit report that goes to the board that
Right.
says, but we have an issue with your internal control, for an example. Now, these are not internal control audits, but they do look at the internal control. And say you have the same person at the housing authority who is writing the checks and then reconciling the bank statement after that. That would be an issue with internal control, and they would advise that those tasks be separated into...
That wasn't happening here?
Well, no, that was not. They actually had an accounts payable, accounts receivable person. But that, usually in a closely held corporation, in a small corporation, you don't have, those functions are not separated. In every audit opinion, in every letter you'll see, will say, we recommend that you segregate those duties. And the segregation of duties is a big part and usually contained in those letters that go along with the audit opinion.
I still can't find that opinion, the opinion you mentioned. Could you?
Which one? Cammy Maloney?
Yeah, could you give us the site to that?
If you give me 1 second, I can give you the site. I think it's towards the end of the brief.
You're talking about the end of the amicus brief?
Yes.
It just, you don't list it in the,
Yes, it's on
Table.
page 21.
okay.
It's AGM Marine Contractors, Inc. versus Cammy Maloney and Company. 71 Mass Ave Court, 11/19/2008.
So it's a 128?
I'm sorry?
It's a 128 opinion?
Yeah, and they affirm the
The unpublished opinion is what he's saying.
summary judgment. I actually have it. I'm happy to forward it to the court. I hope I have it. In my recent change of law firms, I might have issues locating it, but I know I have it somewhere.
Okay, thank you.